SJC-12437, Commonwealth v. Frankie J. Gomez.
Sure, it's their loss that they're not seeing two such capable of attorneys. So.
Happens to me all the time. Just leave.
I'm sure has no bearing on don't take it personally, so. Mr. Curran, you may proceed.
May it please the court, Dana Curhan representing Frankie Gomez. We're here asking that this court allow conditional pleas. Every state in the country and plus the federal system have some sort of mechanism for preserving the right to appeal short of a full-blown trial. The question going forward is whether that's going to take the form, the present form of a trial on stipulated facts or evidence or a conditional plea.
And one other question, a couple of questions actually. One is, do you want a conditional plea with or without the agreement of the Commonwealth?
We want one without the agreement of the Commonwealth.
Okay. But you take one with the agreement of the Commonwealth.
Well, if that's all I get, then I'll take that. But
and then the other is, do you think this is best done by case law or best referred to the Rules Committee or?
Probably a combination of both. A lot of, the majority of cases, there are 30 cases that have conditional pleas. And most of them are by rule or statute. There are only a couple of them that are by judicial decision. But as the amicus brief points out, a number of those cases that are now by rule or statute started out as a judicial decision. So I think we can start out as a judicial decision and refer it over to the Rules Committee. That might be the way to do it.
Now, right now, of course, we don't have such a rule, and the rule was recently amended without any reference to the federal rule. If you were to go without such a rule, tell me what you understand would be the procedure with regard to a stipulation concerning trial. You and your sister seem to have a somewhat different view about stipulation of facts versus stipulation of evidence, and I'm worried as to how it would play out.
Well, I mean, we've had this mechanism for doing stipulated facts or stipulated evidence, and I think it's a kind of a subtle distinction, and I'm not sure how much of a difference it makes, except that there's a risk that if you're stipulating the facts, then maybe you're actually admitting the elements of the crime, and you're doing the equivalent of a plea that may not preserve your right to appeal. But that's not really I think the main objection to a trial in stipulated facts. They've been going on for at least 30 years. It is a constitutionally deficient way of trying a case, so in order to make it constitutionally acceptable, you have to go through a colloquy where the defendant waives his, not only his right to a jury trial, but his right to confrontation, his right to testify, and a few other rights. And as a practical matter, that hasn't really worked. I think I cited 6 cases in my brief where the judges completely screwed up the colloquy.
Yeah, that seemed odd to me, that basically one of the arguments is we need conditional pleas because we're really bad at stipulated trials.
That's certainly the case. 2 weeks ago today, the Harris case in the appeals court, it happened again. So if I'd written my reply brief 2 weeks ago, I would have included that one too. Nobody knows how to do these things, or not enough people know how to do them, because they're not in a rule, they're not in a statute. You have to take a bunch of judicial decisions and say, okay, the appeals court and the SJC say this is the way you have to do it, and you have to get everybody on board and do this.
So if we have to select between the two options here, the stipulated trial, to give guidance on stipulated trials versus acceptance of a conditional plea, why should we go for the conditional plea option? Why is that better than a stipulated trial?
Well, I think for a number of reasons it is, if the Commonwealth talks about finality, if you want to talk about finality, a conditional plea is probably more final because a defendant comes in and pleads guilty and admits to the facts, and the only thing that is left is this appeal that will address a pretrial, probably a dispositive pretrial motion, and once that's decided against the defendant, then you have finality. trial on stipulated facts, maybe you still get that finality, but maybe you have something goes wrong during the course of the proceedings, and somebody comes up with generally doesn't have to be such a brilliant argument, but comes up with an argument that things weren't done right. And I think, for that and a number of reasons, a conditional plea is a lot cleaner. You don't have to argue over, well, I'm probably getting ahead of myself. I don't know if I've answered your
Oh,
question.
you have, thank you.
Let me suggest another benefit. Sometimes at the motion to suppress date, you have a draconian mandatory minimum. Let's say, before the changes in the mandatory minimums in drug cases, sometimes you had a 15-year plus a 2-year.
That's right.
So you had a 17-year mandatory minimum. And there's a motion to suppress of, maybe it's not the best motion to suppress, but it's not the worst motion to suppress. And the government and the defendant would like to plead the case out to maybe half the mandatory minimum, but the defendant can't give up the motion to suppress. If you have a stipulated trial, it has to be a stipulated trial to the charge, whereas a conditional plea could be a conditional plea on a breakdown.
Are you saying on a lesser charge?
Right.
Well, that's certainly the case. There are a number of ways of handling a conditional plea. A conditional plea with the agreement of the Commonwealth can be a conditional plea to a lesser charge or to some particular sentence.
So you got ahead of me there with my next point, but implicit in that is with the agreement of the Commonwealth and the court, just like the federal rule.
That's right. Now, here's why you might not want to, here's why you might want to let the defendant do this as a matter of right. Essentially, a defendant who says, well, I just want to plead, I don't want to take a deal, basically, I think the amicus brief says it's like buying a car at full sticker. I'm pleading guilty to all of the facts, I'm pleading to all of the charges, I'm admitting to the facts, and I'm going forward, and I should have a right to do that. If you require the Commonwealth to agree to that procedure, the Commonwealth can say, okay, I have a case with a really good motion to suppress. It didn't succeed, but there may be a good appeal. I'm not going to agree to this procedure. And so the Commonwealth can effectively pick and choose which cases are going up. And that is why I suggest that there should be a right, just as there's a right to do a non-negotiated plea, there should be a right to do a conditional plea even over the Commonwealth's objection.
And do any states have that?
I'm not sure. Some of them might. I apologize. I got into this case the day before the reply brief was due, and I got 30 days, and I did what I could. I
do know that you identified many states, so you
Right.
have done. But I thought most of those were following the federal example.
Most of them are. And I can't tell you that all of them are, and there probably are a few that allow it, but I don't know the answer to that question.
Now the practical consequence, I would think, with permitting a defendant to do so without the approval of the Commonwealth is that just as defense counsel believe they have an obligation after every trial to appeal as they can, would they not feel the same obligation after every plea is to challenge the underlying decision on the motion to suppress?
Well, I don't think so. I don't think everybody would. I think probably the first instinct of every defense attorney would be, let's make a deal. We lost the motion to suppress. We have a decent appeal. Let's see if we can work that into a plea for some lesser charge. So there would be an agreement, probably in the majority of cases. If there's a really good motion to suppress that probably should be appealed and heard by this court, there's an incentive for the Commonwealth to say, you know, we're not going to agree to this. Go to trial, unless you want to take this, you know, what's behind door number 2. So that is probably probably fairly limited circumstances where you want to allow a conditional plea over the defendant's, over the Commonwealth's objection.
If I can step back, part of the concern that you identify is that nobody knows how to do a stipulated trial. If we were to provide guidance as to that, what would the guidance be?
Well, it would probably be another case like we already have from this court and the appeals court saying this is the colloquy and this is how you need to do it. And then...
And would it be stipulated, I mean, there's a distinction between we stipulate that this is what the evidence will be, which generally goes to sufficiency, as opposed to we stipulate that these are the facts, which generally is an agreement as to the facts, and I think we have said that a judge or a jury may accept those facts as true.
I think probably these should go on stipulated evidence so that then the judge will make a finding that that evidence is sufficient to satisfy the elements of the crime.
It's not, but if it's a stipulated trial, the judge is not making a finding of sufficiency, the judge is making a finding beyond a reasonable doubt.
Well, that's right. And it gets, there's a risk if you stipulate to the facts, there are a couple of cases where the defendant effectively stipulated to that the evidence was sufficient to, you know, here's the evidence and it is sufficient to satisfy the element, and that turned into a plea or could have been read as a plea and may have been read as a waiver of the right to the appeal. I don't think there's a...
Have we ever, or has the appeals court ever done that?
There's one case, and I forgot which case it is, but one case they said, you know, that's one of the many screw-ups here, and we could have done this, but we're not going to because there's so many things that went off the rails here.
Yeah, but the problem is if there's two choices, as the chief mentioned, stipulation of facts or stipulation as to what the evidence might be. If it's a stipulation to what the evidence might be, you know, then the judge doesn't have to accept it.
No, the judge doesn't.
Right. That's the whole Commonwealth versus Ortiz stipulation.
Yeah, I think that that's probably one of the many pitfalls of continuing with this procedure. Again, it's a minority view at this point. There are about 20 states that continue to do this, and you know, more than 30 years ago, I think was the first case where they looked at it and said this was not done right. 2 weeks ago is the most recent. The message hasn't gotten out. There's no rule that says you do it this way. There's no statute that says you do it this way. There are just cases, and even to the extent that those cases are fairly clear, judges and parties have not really been doing it right.
We can underline it.
Well, you could. I'm not
I mean,
sure
of course,
how that would work.
if we do it by the common law, then we have that same issue of the arguable lack of specificity that would be reflected in a rule, and we also don't necessarily have the benefit of the comment period and of the different points of view of the committee to formulate the rule.
Well, I think we could start out by saying generally there is a right to do this, but I think a plea is easier to accomplish than a stipulated trial. And I think less complicated is probably good in this situation. Most judges know how to do a trial. Know how to do a plea. And as far as, I remember talking a lawyer through this and having to, in the middle of the day, put on a suit and go down to the Somerville District Court and talk the judge down off the rail. The judge was not, well, this is a plea, isn't it? This doesn't make sense. I think if we have these as pleas as conditional pleas, it would make sense, and it's a lot easier to implement.
Although if we just adopt a conditional plea, it won't eliminate stipulated trials necessarily. You'd have to go a step further and say, don't ever do this, to avoid that problem.
That's probably a good idea, actually. And I think there's no need to, if there's an ability to do a conditional plea, there's no need to do a trial on stipulated facts or stipulated evidence.
Well, and, other than, no, that's right, that's right.
Unless there are any further questions, I'll leave the remaining points to the briefs.
Okay, thank you.
Thank you.
Ms. Johnson, good morning.
Good morning. May it please the court, my name is Melissa Johnson. I'm an assistant district attorney in Middlesex here on behalf of the Commonwealth. And I'd like to start off with trying to answer some of the questions that came up during my brother's argument. The first question was whether this court could change the procedure on its own. And my response to that is technically yes, this court could do that. The Commonwealth would submit that's probably not advisable given the fact that nearly every jurisdiction that has done this procedure has done it by rule or statute with a full exploration of the pros and cons of the procedure.
But when you say on our own, you mean by common law decision, because ultimately the rules are ours too.
Yes, absolutely. That's what I meant, and I apologize if there was confusion. And as we know, the common law for decades has been that a proper voluntary knowing and counseled plea waives all non-jurisdictional defects. So to craft some kind of radical departure by decision without any kind of guidance from the Rules Committee or from either party in terms of the prosecution and defense bar would in effect be problematic, and that's why so many.
What prohibits, if there is agreement, and I understand there may not be, but if there is an agreement to do this, what would prohibit two parties and a judge from doing this?
What would prohibit it? My first response to that is that the rules do not authorize it.
Well,
So-
right, but they don't cover everything.
Well, they do, Your Honor. I would argue that they do. You have Rule 12, which purports to pretty much cover all of pleas, the acceptance of pleas, plea agreements. And if you look at the history of Rule 12, vis-a-vis the federal rule was enacted in 1983. Since then, we've had, and this is kind of going back to, should we change the rule or not? Going back to that date, we've had 3 major amendments to that rule. One of them was in 1986, the next one in 2004, the next one in 2015. And this court has said that when you have a statute or a rule, a federal statute or rule that differs in material respects, and it does differ from some previously enacted federal rule, then you can assume, you can infer that the Rules Committee or the legislature has taken that into consideration and rejected the federal. And in fact, we see an example of that in Commonwealth versus Wilson. In Wilson, this court was discussing the Massachusetts Rule 12F, which talked about whether we could admit statements of a defendant in the course of plea negotiations. Now, our rule is much more limited than the federal rule, and it was adopted after the federal rule. And this court said, look, where you've got a previously enacted federal rule and we've differed from it, that is an implicit rejection of the federal standard. So it's been 35 years since the federal rule was adopted. And this court has and the Rules Committee and the legislature has steadfastly refused to jump on that federal bandwagon. Refuse to do it. And I think it's because there's a couple things at play here. Number one, the plea, in and of itself, a plea is a plea here. Plea is recognized by this court and also by the public and by the victims as the final and just conclusion to a criminal process. It's recognized as a full acceptance of responsibility. And this court, throughout the 35 years that this whole conditional plea thing has been at play, has held that steadfast instead of adopting the conditional plea. And at the same time, while it's holding that principle up to the public and to the victims, at the same time providing numerous opportunities for a defendant along the way to challenge police conduct in the form of an interlocutory appeal, in the form of stipulated evidence trial, even after the fact in the form of motions to withdraw based on ineffective assistance of counsel. And I would point out with the interlocutory appeal, that Rule 15, was just revised to make it more user-friendly in terms of the timelines. And if you look at the other jurisdictions which have toyed with this conditional plea, they pretty much said, you can't have both. Basically, a conditional plea is going to make the interlocutory appeal process somewhat obsolete. So we have an example of both Vermont and Georgia, which have struggled with this issue. With Vermont, they adopted the rule for conditional pleas. When defendants have tried to do an interlocutory appeal from motions to suppress, Vermont Supreme Court said, no, you can't do that. You can't. Why would we let you do that if there's a conditional plea available? In the reverse, the Georgia courts have basically said they tried to adopt this conditional plea process, but felt that it got in the way of their interlocutory appeal process, and in the end, they did away with conditional pleas. So I would keep that into consideration, that we have struck a balance over the last 35 years in response to this federal rule change back in 1983, that here in the Commonwealth, we're going to recognize that a plea means a plea. It means a full acceptance of responsibility. That's what the public believes it means. That's what the victims believe it means. And at the same time, we are going to create these avenues for a defendant to challenge police conduct.
So what is your view as to the stipulated trial, which exists? We've seen cases coming to us in that form.
Yes.
Is it a little bit silly for us to say you must do this dance, which people often trip on when they're trying to do it?
Well, first of all, I get what you're saying. I don't really see it that way. I see it as a nod to the principle that a plea is a plea, we're not going to mess with that, and a trial is a trial. And the only problems that have cropped up with the stipulated evidence trial, it has survived the test of time, lo these many years. The only problem is that a handful of judges can't seem to get the colloquy right. This is the perfect opportunity for the court to educate or re-educate, as the case may be, on what that colloquy is. Commonwealth versus Montero, which is the appeals court case that laid out what the colloquy is, this court can certainly use that as a template, as to advise judges what to do. You know, it doesn't happen that often.
That colloquy isn't, I mean, do you agree that that colloquy is going to look a lot like a colloquy for a guilty plea?
It is going to look a lot like it, but there's a distinct difference, because the defendant is not fully accepting responsibility as they would in a plea.
Well, that depends upon whether it's stipulated facts or stipulated evidence.
Well, what the defendant is stipulating to certain facts, which in the end, the judge is deeming that prove the case beyond a reasonable doubt. That's very different psychologically. It's very different from a principal perspective, from the public, for the victims, for someone to say, I am stipulating that this evidence is sufficient. I am stipulating that, not the judge finding that. I'm stipulating that this evidence is sufficient for a judge to find me guilty, and I am in fact guilty. And the victim hears that, the public knows it. That's very different, sacrosanct, formal proceeding where a defendant is accepting responsibility as to those facts and what it means in the end. And I think that's something that this court has held up for the last 35 years, lo this many years, while other jurisdictions have jumped on the bandwagon. Not all of them, probably about 29 of them have. That's, you know, a slight majority, but it's certainly not all of them. Yet at the same time, we've preserved our statutory and rule landscape, whereby we've got the interlocutory appeal process. We do have
But the
this.
interlocutory appeal process mostly benefits the Commonwealth, right? I mean, our Rule 15, if it's decided erroneously, the Commonwealth is out of luck, so we tend to reverse it. If the defendant is out of luck, they can always challenge it after trial, so we don't really give them relief on these types of issues.
There was a
So-
case just a couple years ago, I think the Mora case, where this court said this was wrong, you know,
Not that often, though, right?
not that often, you're absolutely right, and I think most of the time these motions do get denied properly, so it is really there to, for the most part, preserve the Commonwealth's right to go forward. And on that note, if that answers your question, on that note, I think there was some discussion about whether this could be done with or without the agreement of the Commonwealth, and I'd like to just spend a couple minutes addressing that, if I may. Basically, our position is, and I would say that almost nearly all of the jurisdictions that have adopted this rule, either by common law or by rule or by statute, have said that it has to be with the agreement of the Commonwealth or the state or the people, whatever they refer to themselves as. It has to be, because the reason is because to do it any differently would be to violate separation of powers. And that the reason is because if you're going to, who's to define what a dispositive motion is? What is a motion, the ruling which basically stops the Commonwealth's case? Only the Commonwealth is in that unique position to figure out how much evidence we have. Can we go forward without this? Can we develop evidence to perhaps get us to that point, even if this evidence has been suppressed? Some cases are a little bit more clear-cut. People have in mind perhaps drug and gun cases. Even in those cases, I would submit it's not crystal clear. There are conspiracy cases that we could still go forward with. Even in this case right here, we've got a distribution charge. If there are multiple charges, in this case, we have a distribution charge that we could possibly go forward in.
But, Ms. Johnson, so the question that I have is, why shouldn't there be a conditional plea if the Commonwealth wants to do it and if the court agrees? Because sometimes you're about to start the motion to suppress, and it's very helpful for the alleged victim to hear the acceptance of responsibility, and it's really hard for the defendant to do the 15 years without at least litigating the motion to suppress. And both sides want to do it, but you end up doing the motion to suppress anyway because there's not this option. So the question is, what's the harm if the Commonwealth has to agree?
I think theoretically, the way you put it, there is no harm if we do. The Commonwealth does agree. My position from the very beginning, though, I stand by my position that it is not authorized by Rule 12. It has to be authorized by a rule or a statute.
No, assume that.
If we assume that, and I'm not going to concede that argument, if we assume that, there's less of an issue if we do in fact agree to it. I think the forefront of our mind, of course, is always that the defendant is accepting responsibility, that that's okay with the victims, that this unique procedure is being put in place. But we would have to agree to the procedure for the reasons that I've just said. To do otherwise, if it were the defendant or the judge who's deciding in the abstract, oh, this motion is dispositive, that in effect will preempt our presentation of the case. We have to be the one to agree to the procedure.
Can you see any benefit to the Commonwealth in agreeing to such a plea?
Not off the top of my head, as long as there's still a possibility of a stipulated evidence trial. So I don't think it's something that we would necessarily need to do.
Do you think any issues regarding costs of defense play into this, that sometimes it's very expensive for a defendant to press for a trial or to have actually even a stipulated trial, whereas a motion to suppress and a guilty plea can be much less costly for them?
No, I do see your point, Your Honor. To be honest, with the stipulated evidence trial, I think we've kind of made the point that it really doesn't look that much different from a plea in terms of time, of cost, and all of that, but it is really the recognition that a plea is a plea and a trial is a trial in our under our system, and so it's the logical.
But also we
practical
also have
offshoot.
under our system the idea that we have issues of law that in a motion to suppress for, obviously, but where, legally and as a matter of law, there's a constitutional error, so the defendant is going to be able to have a good outcome for him or herself.
Absolutely.
Whereas there are factual issues also and realities. And so those two, we operate with those two things all the time, don't we?
We absolutely do, and I think that's why over the last few decades that this court and the Rules Committee and the legislature has really struck the right balance between honoring the principle of what a plea stands for and yet at the same time, as I said before, providing the defendant with many meaningful opportunities to challenge police conduct throughout the whole process. And one of the logical offshoots of that is the stipulated evidence trial, which is still viable. It's a still viable vehicle. It's never been ruled unconstitutional as long as the colloquy is given to the defendant.
Do you think this is going to have a big impact on the appellate docket? I mean, all these cases that plead that don't get appealed, I have this sense that we're going to create this giant category of cases where people have relatively satisfactory appeal, but there's that chance of getting rid of your conviction, so we're going to have all these extra appeals. Is that it? You worried about that at all?
I would be lying if I
Given
said
that you'll
in
have
the
to
back
be
of my
writing all
mind-
those briefs?
I love my job, Your Honor, I do. But in the back of my mind, I do wonder about how our workload would increase after this. We do handle a lot of interlocutory appeals, but now to turn those as basically a matter of right after the fact, I think it would increase our workload quite a bit.
I'm sorry, as a matter of right, are you referring if the DA were to agree?
If the DA were to agree to a appeal after the fact of the motion.
Right, I'm a little bit confused. Are you worried about the consequence on the number of appeals if we were to permit essentially the federal rule, or are you concerned about what the consequence would be if we simply said that the defendant has the right to appeal without the Commonwealth's agreement?
I'm concerned with both. Honestly, I'm more concerned without the agreement for the separation of powers. But even with the agreement, I think we would have to rethink, are we putting the burden on our trial team, or are we putting the burden now on our appellate team?
And do we have any data as to what the consequence has been in those states which have done it, or whether the federal government has seen a material change in the number of appeals when they've done it?
Only anecdotally, there hasn't been really data, and it has increased somewhat. But then again, perhaps they have less interlocutory appeals, so you'll get it either way.
Can we discuss for one brief moment Mr. Gomez? They proposed a conditional plea.
Yes.
Initially, the Commonwealth said, sure. Then the Commonwealth thought about it and said, I don't think so, because we don't think there is such a thing as a conditional plea. If we were to say there is no such thing as a conditional plea unless and until the Rules Committee and this court were to incorporate it in Rule 12, but you could, of course, do a stipulated fact or evidence trial and identified how that would be done. Is it your view that, what happens to Mr. Gomez? I'm just trying to figure what happens to him.
Well, first of all, I don't think we ever agreed to this, the conditional plea. I think that our response was, I'm not familiar with that procedure. Let me talk about it with our appellate bureau and our supervisors, and then came back and said there's no such thing, we don't agree to it. What would happen to him if
we were to say, here's how you can do it through a stipulated fact and or stipulated evidence trial? Has your office taken a position as to whether it would agree to that? Or is it waiting on this appeal?
we would agree to a stipulated evidence trial? That was our position. But the judge did not agree to that. He decided to report the question.
Okay. The judge rejected it, or the judge said, I'm going to first report the question?
He said that, and this is not in the record, so it's just, if the court doesn't mind me saying that, he just said it would be a waste of time.
Okay, but that's
Not
not.
quite, I
that's- that-
undersure.
That's not part of our record, and we
Right.
therefore don't quite know what that means, so.
Right, and I didn't know either, since it's essentially the same as a plea, Your Honor.
Okay.
So if we kick this to the Rules Committee, how does that, I'm still now confused of how that affects it. If we decide you don't have a right to this, but we think it's an idea worth further evaluation at the Rules Committee level, how do we resolve Mr. Gomez's case? Say, you're.
I would say, if the court is inclined to do that, just say at the present time, we don't recognize a conditional plea. However, these are the vehicles that you could do to preserve your right to appeal the motion to suppress. One of the vehicles is a stipulated evidence trial, and the procedure is laid out very clearly in Commonwealth versus Montero. So that would be how to resolve this particular case. But again, before this court, and the Commonwealth is not opposed to any full or fair exploration of how to make the criminal justice system more effective, I would just simply look to the history of Rule 12 for the understanding that I do believe the Rules Committee has already considered the federal rule and has rejected it in favor of the balance that we have struck for the last.
We're lucky we have the former chair of the Criminal Rules Committee sitting before you, so we can ask.
Thank you very much.
All right, thank you.
If there are no further questions, thank you very much.